The meeting of the Hawaii Law Enforcement Standards Board is being called to order at 12:11 p.m. on today as Thursday, December 11, 2025, and is being held in accordance with Chapter 92 of the Hawaii Revised Statutes. As approved at our last meeting, public oral testimony will be limited to 2 minutes. Victor, can you please take roll?
Matthew Devont,
Present, and I'm alone in my office.
Director Mike Lambert,
Present, alone in my office.
Chief Jason Radula is unconfirmed. Gary Yamashiroya,
Wait, hang on. Jason, taking roll. I see him. If you can unmute. Sorry, Jason, you're muted.
I can continue and come back.
Please.
Gary Yamashiroya,
Present and alone in my office.
Chief Vanek,
Present.
and are you alone at your location?
Yes, I am. I'm alone.
Chief Mahuna,
Present,
Sorry.
and I'm by myself in my office.
Assistant Chief Okamoto,
President, alone in my office.
Assistant Chief Sherry Bird,
Present, alone in my office.
Jared Radula,
I'm present alone in my office.
Adrian Dakwa,
Present alone in my office. Thank you.
Greg Tanaka was unconfirmed. I received an email from him this morning that he will not be attended, so he is excused. Nicholas Schlapek,
Hi, that's me, present, alone, ready to go.
okay. And notifying the board prior to the meeting that they would not be able to attend are Chief K of Kauai and Harry Kubajiri from Hawaii County. And that is our roll call.
Thank you. Can you announce about the accommodations?
Welcome to this meeting of the State of Hawaii Law Enforcement Standards Board. This recording provides information on meeting access and accommodations for this public meeting. Meeting access and accommodations. Internet access. To view the meeting and provide live oral testimony, please use the link at the top of the agenda. You will be asked to enter your name. The board requests that you enter your full name, but you may use a pseudonym or other identifier if you wish to remain anonymous. You will also be asked for an email address. You may fill in this field with any entry in an email format, such as email name at emailprovider.com. Your microphone will be automatically muted. When the chairperson asks for public testimony, click the Raise Hand button on your Zoom screen to indicate that you wish to testify about that agenda item. The chairperson will individually enable each testifier to unmute their microphone. When recognized by the chairperson, please unmute your microphone before speaking and mute it again when you finish. Phone access. If you cannot get internet access, you may join by phone for audio-only access using the phone number and meeting ID listed at the top of the agenda. After dialing, you will be prompted to enter the meeting ID. Then you will be asked to either enter a panelist number or wait to be admitted into the meeting. If you are a member of the public, you will not have a panelist number, so please wait until you are admitted. When the chairperson asks for public testimony, you may indicate that you wish to testify by pressing *9 on your phone keypad. After pressing *9, a voice prompt will let you know that the host has been notified. When recognized by the chairperson, you may unmute yourself by pressing *6. A voice prompt will confirm that you are unmuted. Once you are finished speaking, press *6 again to mute yourself. For both internet and phone access, when testifying, you will be asked to identify yourself and the organization, if any, that you represent. Presenters will be limited to a reasonable time limit as established by the board, with exceptions as granted by the chair, vice chair, or designee. Requesting disability accommodation. If you need an auxiliary aid, service, or other accommodation due to a disability, please contact the board as soon as possible, preferably at least 2 days prior to the meeting. You may email atg.lawenforcementstandardsboard@hawaii.gov or send written correspondence to Law Enforcement Standards Board, care of Department of the Attorney General, 425 Queen Street, Honolulu, Hawaii 96813. Telephone 808-586-1160. If a disability accommodation request is received late, the board will try to obtain the requested aid or accommodation, but cannot guarantee that the request will be fulfilled. Upon request, this notice is available in alternate formats, such as large print, braille, or electronic copy. In the event that the audio-visual connection to the Zoom meeting is lost, the meeting may be recessed for up to 30 minutes to restore communication. If communication cannot be restored within 30 minutes, the meeting may be continued to an alternative date and time. In the meantime, please try to reconnect using the same link used to initially access the meeting. Written testimony. Members of the public may submit written testimony by emailing or mailing it to the following. Email atg.lawenforcementstandardsboard@hawaii.gov or mail to Law Enforcement Standards Board, care of Department of the Attorney General, 425 Queen Street, Honolulu, Hawaii 96813. The board requests that written testimony be received at least 2 days prior to the meeting. Late written testimony will be retained as part of the record and distributed to board members as soon as practicable, but we cannot ensure that members will receive it in time for review before decision-making. Board packet materials. Board packet materials will be posted at https://ag.hawaii.gov/law enforcement standards board. Thank you for listening. This concludes the information on meeting access and accommodations for the Hawaii Law Enforcement Standards Board.
Thank you, Victor. Okay. with
Adrian,
regards,
I apologize. I skipped item 1B, your formal determination that there is a quorum.
I guess for the record, there is a quorum of 11 members, so we can proceed this morning. With regards to public testimony, I believe we did receive written testimony from the NYU's policing project, and that should have been disseminated to members in the chat.
I'm not sure if the chat postings are persistent, meaning if members logged into Zoom coming over from Teams, they may not have seen it.
Brandon just resent it to everybody.
Yep, got it.
I'll give you a few minutes to look that over, those items over. Okay, show of hands or raise your hand or nod. Does anyone need more time? Can we proceed? Move this meeting along? I see Chief Vanek nodding. Greg, you good? Jason, you good? Okay. Anyone need more time? Nope. Thank you, Nicholas. Thank you, Matt. Okay. Thank you, Sherry. Okay. Are there any members of the public here to testify on any of the agenda items? Josh, good morning. Brandon, please let Josh in.
Aloha, can you all hear me?
Yep. We received your written testimony. Thank you. The floor is yours. 2 minutes.
Okay. I'm going to give a brief comment, not on my written testimony, I know later in this agenda, there's talk about whether to have a standing meeting time or not. I think it would be very helpful to members of the public like myself to have a standard meeting time. And second, currently the norm has been to kind of post the agenda and model policies and documents on Friday, Hawaii time. And then written testimony has to be submitted 2 days before the meeting, which often has been Tuesday. So that really only gives folks, even folks in Hawaii, it gives like less than 3 business days to prepare the testimony. And folks in the East Coast, it gives like a day and a half. And for a really, really detailed policy, like the model pursuit policy or the decertification regulations, that isn't an ideal amount of time. So I would just hope the board would consider that going forward. And then briefly, everyone, it seems like, had a chance to review our testimony. We applaud the board and the administrator for revising the pursuit policy in a smart, intelligent way so it complies with Act 210 while still protecting public safety. But there are just a few more I's to dot and T's to cross, including that the delegation for data collection goes to the broader Department of the Attorney General and not the Law Enforcement Standards Board specifically. And there has to be a public rulemaking process from the Department of Attorney General setting forth like collection standards for law enforcement agencies. And that is something that, other bureaus of the Attorney General have experience with. And the last one, there's 4 recommendations in here, but I'll just talk about one of the other ones, which is vehicle contact actions like pit maneuvers and ramming, as you all know, are quite dangerous, as is driving the wrong way against traffic. And if you look at IACP's recommendations, you look at PERF recommendations, you look at a lot of the best pursuit policies across the country, they all either kind of prohibit those tactics or say use them in sparing circumstances when there's a risk of serious injury or death posed to another member of the public by the driver, and there are no other alternatives. And we would suggest revisiting to do one of those standards, either prohibiting or a stricter standard. Thank you for considering my testimony.
Thank you, Josh. Members, any questions, comments for Mr. Parker? Anyone? No? I have a couple of questions. I know Act 210 requires the Department of the Attorney General to publish all the data and make the rules regarding the data collection. Josh, what is the value? Help me understand the value of putting that in when it's already in the policy, when it's already in the statute. I guess I'm not understanding why that would be needed, why we should add that to the vehicular pursuit policy when the statute itself is pretty clear.
Yeah, so in the revised policy that the LESB just published, for the first time, that now includes the statutory language saying the LESB is going to collect from law enforcement agencies these 13 data points. And then the LESB is going, this is what the policy says, is going to write a report and publish a report. I would love, the LASB to study the data and publish a report. But as you just said, the statutory language is clear that this delegation is to the Office of the Attorney General, and that's the office that has to make the rules. And the LASB has other delegations in the statute, for example, to draft the model policy, to issue regulations regarding pursuit intervention tactics, but data collection is not one of the things that was specifically delegated to the LASB. So does that make sense?
Thank you. Any board members, any follow-up questions to that? Any other questions? Okay, thank you, Josh. Moving to item 3 on the agenda regarding the approval of the November 6th meeting minutes. Any discussion? Questions? I don't have any questions. Is there a motion to approve?
Motion to approve the minutes.
Thank you, Vice Chair. Is that Matt?
Yes.
Thank you. All in favor?
Aye.
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 Any nays? Thank you. Okay, motion carried, minutes approved. Okay, item 4, administrative report. Victor, I'll give you the floor.
Thank you, and good afternoon, everybody. So point number A, our website and identity. I did share with some IT personnel and Adrian a state post website that seems to include just about everything that we would want to see if we could possibly replicate that. And that's from the state of Massachusetts. That has a lot of information. We don't have that much information yet because we don't have all of our rules approved and everything else. But if we can set up that structure and be ready to publish to a format similar to that, I think we'll be ahead of the game once we get to that point. And I know that everybody is extremely busy, but I still haven't received bios or a professional headshot of the board members. I think that's something that we can have ready to go sooner than later because we already know who those people are and what your bios are. And then we can begin to post our updates. As Josh had mentioned, getting out as soon as possible on our own website, any rule or statutory or other revisions to documents so that they can be reviewed by the public so that the public can give testimony in a timely fashion. But that's where I'm at on that. Just like I said, identifying examples of what our website should look like to accomplish everything that we need. And then as soon as I can meet with the IT personnel, make sure we can get something similar to that done, we can start to populate it. As far as the launch timeline, I would say no, it's not going to be this year. It'll probably be spring before we have something that's more useful than what we've got now, which is the web page on the AG's office site and something that's ready to go. And not to rush the PIGs at all, but the PIG that's looking at rule number 6, XX-6, which is our code of conduct. That's probably something that needs to be done. And also mission, vision, and values, which was an additional task given to that group, and also a logo or some sort of a symbol, not necessarily a formal state seal, but a symbol that represents the that represents the board. We should probably have those done before we put or publish our own independent web page. Any questions on item A? B, office setup and staffing. I've got a call in, and I'm going to follow up on that next week to the folks who are in charge of the state warehouse to see what new office furniture has become available that we don't have to pay for, that we can just arrange to have moved over to our office and prepare for at least 3 personnel. And I did not receive the formal report, Adrian, but as I understand it, of the 6 positions that were requested, 3 of them made it into the governor's proposal for funding.
That's correct. We can talk about that later in, I want to say item
Okay.
7.
And to Director Lambert's comments and Deputy Director Radula's comments at the last meeting, knowing that those positions are on the horizon, we should probably be ready to support them with whatever resources they're going to need so that we can hit the ground running. Any questions on item B?
Nope.
Okay. Item C, stakeholder engagement. I was able to get in touch with several professors and program chairs from University of Hawaii in sociology, criminology, and administration of justice, especially the administration of justice lead in Hawaii County, who's already working with Hawaii County's agency on curriculum and courses that officers can take for college credit. The main points that came out of those meetings are that there is going to be an opportunity for internships, meaning even though our staffing will probably take a while, we have the 3 coming and then hopefully more in the future. In the interim, as we're able to do so, we should be able to partner and be able to employ some interns to do some of the basic work that needs to be done, and they also get their college credit for that. We also have an excellent opportunity through the sociology department and basically an offer to not collect, but to analyze any data that we come up with. So that will be helpful in the job task analysis. It'll give us an objective third party. If we can have the administration of justice folks on Hawaii County from UH take a look qualitatively at what the job task analysis comes up with, make sure that it's valid and it is a good, accurate reflection of what law enforcement looks like in the state. And then also the sociology department can look at it quantitatively, meaning number-wise, and give us an idea of what we're looking at as far as the heavy lift of implementing all of our new rules and the training standards. So there's some support available through the universities, and that's pretty promising, including an offer. I have not contacted the English professor yet. But as we build out our curriculum, we need to make sure that it's accessible as possible. We as a board will probably make a determination on whether all training materials need to be an 8th grade reading level, probably absolutely no more than a 12th grade reading level, both curriculum as far as lesson plans, curriculum as far as student participation manuals or products or resources, and especially testing materials. If our testing is going to be standardized, which it should be, those tests should be fair in the manner in which they're easily accessible, able to be read and understood by just about every officer that we have with no barriers, and valid. And to that point, that academic validation, if we can get the university's assistance with that, that's going to be a huge a huge task that's taken off of our plate. And basically all those things have been offered and all those things seem possible. So that's very promising. Any comment or questions on item C?
I had a question, Vic.
Yes.
What kind of testing material are you talking about?
So any curriculum or courses or training content that ends up being required by the board for to attain initial certification or to maintain certification of current officers has to be validated in some way. We have to be able to prove that the officer met performance standards, whatever those performance standards are, or performance objectives. So, and usually that's done with testing. I mean, the most basic form would be a multi-choice exam question. So as we're determining in any particular course, what is a passing score? Are all of our scores 100% or nothing? Are they 70%? Are they 75%? How are we going to do that? Hopefully when I get my training and curriculum coordinator on board, that person will be able to put all that together and put it in front of you for a decision on what that should be. And then having an outside academic source take a look at it and make sure that it's valid is important. We need to make sure that there's no trick questions. There's no questions that are so complicated that they can't be understood. And as we get data on which questions are missed consistently, we need to have a plan to revise those tests and revise those questions to make sure that we're addressing why, other than the officer not knowing the material or not being proficient in that topic, the reasons why those questions are being missed, so that we don't fail officers, require retraining, and require retesting for no particular reason, which is will be a waste of time if we haven't done our job on our end up front. That was probably too much to answer your question, but hopefully I answered your question.
You did, thank you.
Okay, without regurgitating all 92 pages, tell us about your administrative plan overview.
So in the chat, without
Sorry,
regurgitating.
So I have a quick question about that testing.
Yes.
Panic. Yeah. Hi. This testing that you're talking about for initial certification, is this a test that's separate from the testing that our officers currently take to become police officers already in our police academies? Is that what you envision?
It is what I envision. So that's the quick answer. And the reason is not because those tests aren't valid themselves. It's because they're not standardized.
And
so
do the police chiefs have a say? Because I would be completely against that.
Absolutely. And that's, I mean, that's the reason for the makeup of the board and the consistency of the board as we move forward. As you look at post-op,
why is it that the police officers would have to take another test? Wouldn't the board just be able to look at our tests to see that our tests meet the standards that are consistent with what the standards are that the board comes up with, to make sure that our tests meet those standards? And if they do, then why wouldn't our tests be able to suffice to certify our officers? It just doesn't make sense to have to take another test. Because what if they pass our test but they fail your test, but all of our tests meet all of the standards of the board? You know what I mean? Then does that mean and then we certify our officers, they take the oath and then they fail that test? Do we then not? I don't know, that's just really confusing.
And that's a common concern and a common issue throughout all the states with where they have state standardized curriculum and state standardized certification standards, which need to be met. At the very minimum, those topics that are required by HRS 139 will probably need to be standardized by the board. the job task analysis will tell us absolutely if what the agencies are doing now independently already meets those standards. And then it would be up to the board to make a determination on whether we allow the counties to continue to operate in that manner, and we just reevaluate on a consistent basis, or if there's a need or some value to making it standardized, which also takes the burden off of the agencies, meaning you wouldn't have to double test your officers. We would provide you the curriculum, we would provide the information, we would provide all the materials. And then when they took the standardized exam, it would be the same for Kauai, it would be the same for Maui, it would be the same for your agency, it would be the same for everyone. And that would be a statewide minimum standard. Just looking around the state right now, I think that more training hours are required by your agency than probably any other agency. And I haven't taken a look at the field training hours, and that's going to be part of the standardization process too, is what's required for field training after basic training before an officer is considered competent by that agency to operate on their own. So as we standardize all these things, and as like I said, the job task analysis will tell us what's being done now and give us a much better picture on what we need to do, and more importantly, what we don't need to do. So when I've been involved with projects like this before, it's usually 85% of what's already being done doesn't have to be changed at all. And the 25% that remains, or 25 or more percent that remains, doesn't need to be altered very much at all, except to meet mandates, whatever those mandates might be. So if there is a state standard on de-escalation, or if we're required to test each officer on knowledge of the new state pursuit policy, I can see that being standardized to make sure that we're compliant with everything that's required by HRS 139. But it should be the board's work and my staff's work to standardize those materials, not the agencies. And then we would pass that down to the agencies to include in your training.
Okay, got it. Thank you.
Gary, I see you have your hand up.
Victor, it might be helpful if you might want to explain, for example, in how it was done in your state that you worked at the board. At least I know that it was just at the end of your training, we had a state certification test. It wasn't comprehensive as probably what the agencies would provide, because each county is going to have its own separate issues and separate things they focus on in training. So maybe it's helpful if you explain how you envision the process to be.
And that's an excellent point, Gary. So the state that I did my 29 years in, Arizona, you were either a police officer or you weren't. It was either you're certified or you're not. There was only one level of certification offered by the state, and it was a absolute state standard, meaning I attended the academy, and when I was the executive officer at the academy, we did our best to train to those state standards, and we gave exams, and you would either pass or fail those exams and either remain or be dismissed from the academy based on your performance. But when it came time for state certification, my staff was not allowed in the classroom. A representative from Peace Officer Standards and Training or the board would show up, and they would administer a 6-hour exam, 3 2-hour blocks on every single thing that they learned over a 21-week period, and that was sink or swim. So they could very well pass our academy standards, but fail the state standards and not achieve certification. In Idaho, where I was post director, was a little bit different because I ran the academy. So everything was on our shoulders, which also meant everything was consolidated. We knew that if you passed our weekly exams, that if you passed our proficiency skills assessments, that you were going to be successful in meeting the state standards, because everything was built to those standards within the basic training course itself. It did not guarantee that students were going to pass those assessments, but it was built in. The only tricky thing in Idaho is that peace officers had full authority upon hire with no training whatsoever. They had a year to attend the academy. So officers who had been working up to a year, if they failed the academy, were told that they were not going to receive their certification unless they came back through the training and could not continue to act in a certified capacity until they did pass. So here I envision, like I said, a huge percentage of what's already being done is going to meet whatever minimum standard is discovered in the job task analysis. And the board will need to determine whether that standard is sufficient, whether it needs to be raised, whether the board's standard needs to be at a level that's lower than maybe 2 of the agencies, but higher than 3 of the other agencies. That could fall at any place with any topic or any proficiency skills standard. And then once those determinations are made, we can figure out how the board can supplement that training and create a certification standard that's consistent for everyone. So a Honolulu PD officer, upon attaining Law Enforcement Standards Board certification, has met the exact same standards as the Kauai officer. It doesn't mean that they got the exact same training. It means that they met the exact same certification standards. Like I said, in Idaho, I was in charge of both, so it was easy. In Arizona, we really had to do our job as trainers because the state didn't care how well we trained the officers or not. They only cared whether the officer passed or not, and they got 2 shots at it. They got to take that 6-hour exam once. If they failed, the next month they got to take it again, and if they failed, they'd have to go back through 21 weeks of training.
Okay, wait. So like Gary suggests, is the AIM one certification standard or different certification levels?
So the certification standard will be the same for each level that the board determines is necessary for law enforcement officers in the state. So my discussions with Director Lambert and Director Radula are going to be interesting when we get to that point about the vast differences in job duties of their personnel, and do they require the same level of certification? Do they employ officers who will never be in a pursuit? Do they employ officers who will never be chasing a bad guy and taking physical custody of them? If they do employ people whose job only requires a lesser level of training, for the board to establish a higher level of training is going to cost that agency time and money that's probably not going to enhance the level of their service delivery at all. So it's worth looking into having different levels of certification, but each level will have a standardized certification model.
Chief Fanek, I see your hand up. Floor is yours.
Yes, thank you. So is there going to be a cutoff date? Will that include, so I hear us talking about a lot of officers coming out of the training academy, but what about our incumbent officers? Will they have to also go through the certification? And what if they don't pass certification?
Built into, and it's rule 2, 3, or 4. I can't think of which rule it is right now, is an 18-month, and I forget which PIG is looking at that rule, but it's an 18-month time differential between a provisional certification, which will be initially issued blanketly across the state to all current officers, to a point where they're assessed to make sure that they meet whatever the board standards are. That might entail taking an extra course in response to mental illness, de-escalation, the new statewide pursuit policy, so that the board can absolutely document 100% that all current officers are trained and have a working level of knowledge of that policy. So whatever the board determines is necessary there will be a time differential between the provisional certification and then establishing ongoing certification, or put them into a mode of continuing education every 1 to 2 years, whatever the board determines is necessary. And I did receive some good guidance from one of the university professors about how to implement that timeline so that we, the board, don't overwhelm the agencies, and so that the agencies don't overwhelm the board, having every officer in the state up for recertification every 2 years is not administratively workable. So we'll have plenty of time to figure out how that's done, how best we can get it done. And from the point that we set our standards, your new officer shouldn't have to worry about it at all. They will have met the initial standards and they'll be immediately go into the continuing education cycle. The current officers will need to look at, and will also need to make a determination on what we do. I'll just give you a quick example. Let's say we have a 2-year continuing education limit. What do we do with that officer that's scheduled for retirement in 1 year? Are we going to require you to, as an agency head, to send that officer to all these different trainings for recertification that they will never take advantage of? So we want to make sure that we don't create an unnecessary burden as well.
Thank you.
Okay, I'd like to move along, keep the agenda moving. Item 5 is regarding the permitted interaction groups on the draft administrative rules. Unless a group is ready to say that their chapter is finalized and it's ready for public input, because of sunshine laws, we can't take a partial report or even an update. So members, please continue to work with your within your group. If you need additional materials or resources, reach out to Victor or myself, let us know. I'd like to see at least one group start reporting back by February or March if possible. If you have any questions, let me know. Otherwise, I'm going to defer item 5 on the agenda. Questions, discussion on that?
I will be
Anybody?
sending out a letter in response to a request from Group D to each agency for internal affairs processes and timelines for investigations. So look for that letter to come out to your agencies and respond in a timely manner if you can, so that I can get that information back to Group D to continue their work.
Follow-up questions, discussion. Okay, seeing none, let's move to item 6 with regards to the model vehicular pursuit policy. This was revised from our last meeting. I've taken a look at the policing project's testimony. Any thoughts, discussion on it? The major change from the last meeting is I tried to clean up that initial set of criteria of what offense you can pursue for, streamline that a little, tried to track the statute better. Questions, comments? Gary?
Just that one issue I brought up at the last meeting, I believe it was section 8, about how is primary jurisdiction defined, especially when you have concurrent jurisdiction. So that's really the only comment I have. So if you have a pursuit, let's say in Honolulu, and you have a DLE officer engaging in that pursuit or initiating that pursuit, who is primary jurisdiction in that situation? Is it the DLE officer since he initiated the pursuit? Because both HPD and DLE have concurrent jurisdiction.
No, that's a great point. Like, say, for example, a few years back, someone escaped from cell block, hijacked a car and took off. I turned to Director Lambert and Chief Vanek. How would that get handled?
Run the scenario by me one more time.
Say there's a escapee from cell block down at Circuit Court. He jacks a car, takes off. DLE starts off, sheriffs start pursuing, and it's into Metro Honolulu. How would that be handled? And how should we handle it in terms of a model policy?
Well, we're kind of, since we're a new agency, we're trying to start to take kind of ownership of things that generate out of the state areas. So let's just say he does, and they are stopped by us, then we would, within our own criminal investigations division, charge that case. If, let's just say they go beyond our reach or we cut and then HPD picks it up, we would then work the initial, and then there would just be an agreement based on kind of how it played out, who would take over the case, whether we would come and relieve them and accept the body, or if HPD would charge on their end. But those are the kind of things that are, along with training, is just the state, I don't want to say finally, it's not fair. Under my direction, we want to be more traditional in regards to the things that we do. But yeah, there is going to be some room for discussion statewide. Relationship is when felonies generate through a state function like the courts, and then those events transition into the broader community, right? The county areas. So if we catch up, then we would close it out. If they get away, then of course we would make the case, and there would be a request from the counties to help locate that individual.
Yeah, and Adrian, I'm sorry. I think my question was a little more basic on which constitutes the primary in this situation, instead of actually because I think, each pursuit's going to be on a case-by-case basis, how it's going to be handled. So, my question is, which would be the primary, and maybe we need to use a different word. If it's the initiating agencies, if it's the initiating agency supervisor that requests that the pursuit be, or not request, but mandates the pursuit be discontinued, then it'll be discontinued. And then the other question becomes, does DLE have the authority to discontinue an HPD pursuit? And that's just something that we need to.
No, nor we're not even on the same channel, so.
Yeah.
So
right.
it would basically be isolated to our own agencies. Yeah. And I doubt anybody would appreciate in either route. The county cutting the state, or county cutting the county. So.
Right. So I think it's just the use of the word primary. I think we just need to change that. That's all.
Yeah. Or initiating, right? If you just change it to initiating, right? Or, so.
Yeah, I would concur with Mike. So it depends on who the initiating agency is. If they initiate, we're not going to, we may provide support, but our policy, it doesn't prohibit. There is a section in there that allows, but we're actually limited to two vehicles. And then if DLE initiates, I'm sure they have specific policies as well of what they should be following. And then, of course, if they should lose the vehicle and then we should pick it up, then it, technically becomes our pursuit. Then we would follow our policies. But then, yeah, our supervisors, if we pick it up, they're going to be monitoring, and then, of course, they can cut it. So yeah, that primary word is a little bit problematic when it involves multiple agencies.
And that's for concurrent jurisdiction. It's a different issue. I think this section of the policy is meant for if HPD pursued into an area that DLNR has responsibility for. What do you do in that situation? So that's again, primary is because they both have jurisdiction, even if it is on DLNR property. So that just needs to be addressed, and I think primary is just a problematic word.
And Gary, you're looking at section 8D Delta, right?
Correct. 8D Delta on page 9.
Okay, thanks. Any other comments or questions? Any comments or questions on Mr. Parker's testimony regarding pit maneuvers, etc.? prohibited restricted tactics.
I guess this is Chief Vanek. I guess the only comment I would have is that right now, our HPD policy prohibits it, so it's not really a concern of ours. Yeah.
Thank you. Greg, Assistant Chief Okamoto, any comments, input on that?
No, it's been kind of mentioned. I concur with everything I've said before right now. So
Thank you. Chief Mahuna, any comments, questions?
No, none. I concur with Chief Vanek. We don't have any. We don't allow that in our policy either.
Thank you. Okay, any other questions, comments regarding the model policy, the draft model policy right now?
Adrian.
Hi.
Hi. So we can still use this time period to compare it with our department policy, correct?
Absolutely.
Okay. Thank you.
Any comments or questions on the rules regarding the data collection and publication as mentioned in the testimony? Anyone have strong positions, thoughts, feelings on that? To me, I didn't include it in the model policy only because it's a vehicular pursuit policy. Act 210's a statute that's fairly straightforward. It tells you what the responsibility of the Attorney General's is to draft rules. I didn't want to make this pursuit policy any longer than it needs to be. But I guess for the next meeting, I'll put in a section and we can decide whether we want it in or out. Comments, questions, any follow-up? Okay. Let's see, item 7 regarding the budget. As an update, we had asked for 6 positions. We got funding, tentative funding for 3, for an administrative manager, a training and curriculum coordinator, and a lead investigative agent. We asked for 919,700. We got 758,840. So not too bad. It gives us something to work with for 3 positions, as well as software. As far as legislative coordination, the certification extension is going to have to get done. I am waiting to hear back from the Law Enforcement Coalition whether they're willing to include our bill in their package. I don't know if any of you have insight or additional thoughts, updates on that, Chiefs.
I don't.
Okay. The civil service exemption, to make the positions exempt from civil service, I cut out the 3. Once we got the funding for 3 positions, I cut out the other 3 that we didn't get funding for. The thought process was to just streamline it. Then we can go back next year and show the progress we've hopefully done with what we were given, and therefore make a stronger case of why we're deserving of increased staffing. Comments, questions? Okay. Let's see. With regards to the annual report to the legislature, that was included in the board's packet. That was submitted already. I think we had tentatively approved the majority of it at an earlier meeting. I don't see, or any comments, thoughts, questions on that? Okay, item 9. With regards to these meetings, I'd like to keep them monthly. I know it's a more frequent from the past, but it does have some level of accountability and transparency for the public, just say we're trying to move things along. Does the current Thursday date work? I know everyone has meetings of their own. What works best for everyone?
To be honest, Adrian, and this is just a recommendation because my calendar fills up pretty tight at about the 60-day mark. So I think what you might have to do is just try to hardline a date. And we're just going to stick to that date, and everybody will start to build their schedules around that through subsequent months. So we just have to accept the fact that whatever we set it at, we might not hit quorum for a month or two until people start building their schedules around that hard date. So I think the bigger question is especially with the counties, is what are your recurring admin? Because then you're going to be asking the agency to move around their entire schedule. For example, HPD meets, twice monthly with command staff. So I think that if we just kind of work it backwards and say, what are your guys' hard no's? In other words, you guys already have agency commitments, and then we try to kind of do like a review poll on it, right? And then we pick a date, and then everybody can move forward and build their schedule around it. That's just my recommendation.
Sounds good.
Would this?
Chief Vanek,
this-
Chief Vanek, your thoughts?
Yeah, I'm good. Thursdays are typically good for me. Wednesdays don't work, but if you let me know like a month or two in advance, I'll make it work. Right now, January is okay just because that's the beginning of the year, but I concur with Mike.
Okay. Chief Mahuna?
Right now, I have the state 901 board that meets at 900. I think it's the second Thursday of every month, which I think it's conflicted with this meeting at least a couple times. I think I'm not 100% sure, but that's what I have. That's what I have monthly recurring.
Okay. Would the third Thursday work for everybody? I see Nicholas nodding your head. Thank you. Chief Verdillo, would that work?
That looks good for me.
Thank you, Chief Mahuna.
Yeah, Adrian, it'll work for me. Thanks.
Okay. Chief Vanek, it's okay.
Third Thursday each month or just next month?
Third Thursday from here on out.
Yep, looks good.
Okay. Director Lambert.
Yeah, good to go.
Okay. Matt.
Yes, that works.
Okay. Gary.
Yeah, I'm sure it'll work for the director or me.
Okay. Greg, Chief Okamoto.
Yep.
Okay. Jared. Should be okay.
You got to be where I am, so yeah. Just kidding.
Yeah, what my boss
Sherry?
said. Thanks.
Sherry, would that work?
Yeah, that'll work.
Thank you, guys. I appreciate that.
Time of
thank you.
time of day.
I like 10 o'clock only because I got to be honest, sometimes we're busy and I actually use the hour to prep ahead. So full transparency on that one.
Okay, that works. Okay, anything else? I think that's it. Last item, public comment on issues not on the agenda for consideration for the board's agenda at the next meeting. Any comments, any members of the public? Seeing none, is there a motion to adjourn?
Motion.
Can I get a second?
Second.
Okay, I have Director Lambert, and is that Gary and Sherry tied for second?
Yes.
Okay, hey, I appreciate everyone signing on for this. Keep working at your draft rules. Everyone have a happy holiday. And we'll see each other next month.
Merry Christmas.
Thank you guys. Thank you.
Okay, guys.
Take care.
Bye.